When someone dies, their bank account gets frozen immediately. The moment the bank finds out, nobody gets access. Not the spouse, not the adult children, not the executor named in the will. The account is locked, and the family is left waiting. This happens to thousands of American families every single week. People who thought they were prepared. People who had a will. People who assumed the hard part was the grief, not fighting a bank for access to money their loved ones spent a lifetime saving. In this video, you'll learn the one thing that determines whether your family gets that money in 3 days or spends the next 3 years waiting in court. Most people never think to check it, and by the time they find out it matters, it's already too late. I've gone through hundreds of real probate cases so you don't have to. Families who got it right, families who got it badly wrong. And the difference between them is simpler than most people think. One conversation, one form, one decision that takes 10 minutes to get right. Let's get into it. Here's the situation most families find themselves in. A parent passes away on a Tuesday. By Thursday, the adult children go to the bank to handle the account, withdraw money for funeral costs, pay outstanding bills, just get access to what their parent left behind. They bring the death certificate. They bring their ID. They've done everything right. The bank says no, not because the family did anything wrong, not because there's any dispute, simply because the moment a bank is notified of an account holder's death, they are legally required to freeze the account. It's not a policy choice. It's not something a manager can override. It's the law. Frozen means nobody can access it. Not the spouse, not the children, not the executor named in the will. Nobody until the legal process is complete. And that legal process has a name most people have heard, but few people truly understand. It's called probate, and it can take anywhere from 9 months to 3 years. In some states with backlogged courts, even longer. During that entire time, the account sits there, the money sits there, and the family waits. And it costs money, real money. Attorney fees, court filing fees, executor fees, appraisal costs. The average American family spends between $10,000 and $15,000 going through probate, sometimes far more. That's money coming directly out of the estate your loved one spent a lifetime building. There was a case in California where a family waited 26 months, over 2 years, just to access a checking account with $47,000 in it. By the time probate was finished, more than a third of that money was gone in fees. The family received less than $30,000 of the $47,000 that was sitting in that account. That's not an edge case. That's Tuesday in America's probate courts. So what actually determines what happens to your bank account? It comes down to exactly 4 situations. And once you understand them, you'll know immediately where you stand and what to do about it. Scenario 1. Named beneficiary. This is the best case. You have a named beneficiary on your account, something called a POD designation. Payable on death. It's a simple form your bank already has. You walk in, name a person, sign it. Done. When you die, that person goes to the bank with a death certificate and their ID. The money transfers directly to them. No court, no lawyer, no waiting. Usually within a few business days. Here's a real example. A woman in Ohio passed away at 71. She had $83,000 in her checking and savings accounts. Her daughter was named as POD beneficiary on both accounts. The daughter walked into the bank 6 days after her mother's funeral. She walked out with full access to $83,000. No probate, no fees, no waiting. That is what a POD designation does, and it costs absolutely nothing to set up. Scenario 2. Joint account. If it's a joint account, shared between 2 people, with rights of survivorship, the surviving account holder gets full access immediately. The account doesn't freeze. The money passes directly to the surviving owner by operation of law, not through probate. But not all joint accounts work the same way. There are 2 types. Joint tenancy with right of survivorship. This is what most married couples have. When one person dies, the other gets everything automatically. Tenancy in common is different. Each person owns their share separately. When one person dies, their share goes through their estate, meaning probate is possible. The lesson here: know which type of joint account you have. Ask your bank specifically. 3 words: right of survivorship. If your account has those words, you're in good shape. Scenario 3. Will only. No beneficiary. This is the one that catches most American families completely off guard. You have a will, you feel prepared, your attorney drew it up, it clearly states who gets what. You did everything right. Here is what most people do not know. A will does not avoid probate. A will still has to go through the court system. It still gets frozen, it still costs money and time. The will simply tells the court what to do with your assets. It does not skip the court. Having a will is not the same as being protected. Here's a real story. A man in Florida passed away at 68. He had a valid, properly witnessed will. He had $62,000 in his checking account and left everything to his wife of 40 years. His wife could not access a single dollar for 14 months. The account was frozen while the will went through probate. She had to borrow money from her adult children to cover basic living expenses during that time. The will was perfectly legal. It did exactly what it was supposed to do. But it still went through probate because that's how a will works. This is one of the most common and most painful financial mistakes American families make, and it happens because nobody ever explained the difference. Scenario 4. No will, no beneficiary, nothing. When this happens, your state's intestacy laws take over. The government, not you, decides who gets your money, based on a formula, not your wishes. Unmarried partners get nothing, regardless of how long you were together. A partner of 20 years with no legal documentation gets 0. Estranged family members may get everything. A sibling you haven't spoken to in 30 years could legally inherit your savings while your closest friends or chosen family receive nothing. And the money could be tied up in court for years, because without a will, the court has to work much harder to determine who the legal heirs are, verify their identities, and track down anyone with a potential claim. This is the scenario that destroys family relationships. Siblings fight, partners are left with nothing. Legal battles drag on, and the money that was supposed to help people slowly disappears into fees. Okay, you now understand the 4 scenarios and why they matter. And here's the good news. The fix is genuinely simple. Most of it is completely free, and none of it requires a lawyer. Step 1. Add a beneficiary to every bank account. This week, not someday, this week, call your bank or go in person and ask one question: do my accounts have a named beneficiary? If the answer is no, ask them to add a POD designation right then and there, payable on death. It takes about 10 minutes. There is no cost, no attorney needed, no legal documents required. You fill out a simple form, you name a person, you sign it. That's it. When you die, your family skips probate entirely for that account. Step 2. Check your retirement account separately. This one catches people off guard. Your 401k, your IRA, your Roth IRA, these all have their own beneficiary forms, completely separate from your bank accounts. Completely separate from your will. Many people add a beneficiary to their savings account and assume they're done. They're not. Retirement accounts need to be updated independently through your plan administrator or brokerage, not your bank. Log into your retirement accounts this week and check. If there is no beneficiary named, or if the name there is outdated, update it immediately. Step 3. Review every few years. Beneficiary designations are not set and forget. Life changes. People die. Relationships end. Children are born. Outdated beneficiary forms are one of the most expensive problems in estate planning. People forget to update them after a divorce, and their ex-spouse legally inherits their life savings. It happens constantly. Set a reminder. Every 3 years or after any major life event, marriage, divorce, a death in the family, a new child, review every beneficiary designation you have, all of them. These 3 steps could save your family months of delays and thousands of dollars in fees, and not one of them requires a lawyer, a notary, or a single dollar to complete. Let me bring this all together. When someone dies, their bank account gets frozen the moment the bank is notified. What happens next, whether your family gets that money in 3 days or 3 years, comes down to one thing: whether there is a named beneficiary on that account. A will alone does not avoid probate. A joint account with right of survivorship usually does. A pod designation always does. And having nothing, no will, no beneficiary, is the most expensive and most painful situation of all. The 3 things you can do right now, today, for free. 1. Call your bank and add a pod beneficiary to every account. 2. Log into your retirement accounts and check the beneficiary forms separately. 3. Put a recurring reminder in your calendar to review everything every 3 years. Those 3 steps could save your family months of delays and thousands of dollars in fees, and none of them require a lawyer. Now, most people after watching this video think the next step is to write a will, and that's understandable. But here's the thing: most people get the relationship between wills and trusts completely backwards, and that misunderstanding leads to exactly the probate situation we just talked about. In the next video, I'm going to explain exactly what a will does and doesn't do versus a living trust. It's one of the most important things you can understand about protecting your family's money, and it might surprise you. If you find this video useful, don't forget to hit like and subscribe.